Thank you. May proceed then.
Today is the 13th of April 2023 in the High Court of South Africa, Gauteng Division, Pretoria. This is case number 006386 of 2022 before the Honorable Justice Collis J, the Honorable Justice Malindi J, and the Honorable Justice Mota AJ. The matter is heard via Microsoft Teams. Thank you, my lady.
May it please the court, I appear together with Mr. Ramukhali for the applicants.
Yeah, I just wanted to put the applicants' names on record. Apologies, counsel.
In the matter between Vindiren Magadzire, the first applicant, Zimbabwe Immigration Federation, the second applicant, and the Minister of Home Affairs, the first respondent, Director General of the Department of Home Affairs, second respondent, Minister of Police, the third respondent, National Commission of the South African Police Service, the fourth respondent, the President of the Republic of South Africa, the fifth respondent, and the Border Management Authority, the sixth respondent, and South African National Defence Force, the seventh respondent. May it please the court.
Thank you.
Thank you, my lady. I appear with Mr. Ramukhali for the applicants.
Thank you, Mr. Nkaitobi. For the respondents.
If it pleases the court, Justice Collis, I, together with Mr. Rosenberg, Ms. Adakari, and Mr. Ibrahim, appear for the first and second respondents. As indicated previously, Mr. Rosenberg will be conducting this part of the or this matter.
All right. Thank you, Mr. Thank you. All right. Mr. Nkaitobi.
Thank you, my lady.
Perhaps could you just start by indicating to the court how much time do you want to be allocated for your argument when you commence?
Until 12:30, my lady.
All right.
And hopefully not more than 30 minutes for reply.
Okay. And the respondents, Mr. Rosenberg?
My lady, if the applicants go on till 12:30, we anticipate then that we would probably go up to about 4 o'clock, leaving the half an hour for reply.
It's also a lunch hour.
Yes, now I've factored that in.
Okay. So it's how many hours?
I would anticipate then that I would be approximately 2.5 hours.
Also 2.5. Okay. Thank you. Yeah, thank you, Mr. Rosenberg. Mr. Nkaitobi?
Milady, may I just put one aspect on record? It may be necessary for us, for the respondents, to deal with an issue up front, and that's in relation to what we now understand is the exact form of final relief that is being sought in this matter. And in the context of what we previously understood was an indication flowing from the short supplementary note filed late on Thursday last week, that the applicants were not going to persist with the application for interim relief. Having seen now what the proposed course of the applicant is, and the nature of the final relief that it seeks on these papers, there are certain preliminary submissions which we think should conveniently be made before counsel for the applicant moves on with the argument in support of the final relief that is sought as presaged in this draft order.
Okay. I think we must first find out from the applicants how they wish to proceed.
Yes.
Get that on record first before you can raise this point up front.
My lady,
on record yet.
we confirm that we will be asking for final relief in the form of the draft order that was uploaded yesterday midday on case lines at 010/1.
And will you be seeking final relief without any amendment to your paper as it stands?
Yes, it's final relief on the papers as they stand.
Okay. And is it the argument of the applicants that the evidence borne out by the paper supports the final relief?
Yes, the clear right is established.
And when this matter was enrolled, it was enrolled for the purposes of Part A
Yes.
of the notice of motion. Are you still just persisting with Part A?
No, with Part B, the final relief is in Part B.
That was not enrolled.
Yes.
Okay. All right. Thank you, Mr. Nkaitobi. Mr. Rosenberg?
Thank you, Judge Collis. As has been confirmed by counsel for the applicants, the matter has now, having been enrolled for Part A adjudication and papers having been filed in Part A, with no Part B papers having been filed, counsel has now migrated the matter, or the applicants have migrated the matter to Part B on the basis that the Part A papers demonstrate a sufficient basis for setting aside the decision in question, and that on that basis, the Part B relief is appropriately to be sought at this stage and on these papers. We submit with respect that cannot be. This was an application brought in two parts. For the purposes of the Part A relief, the requirements of interim interdictory relief were at the forefront of the papers as they were prepared and formulated. For the purposes of the Part A relief, there was never any question that the court was going to reach any final definitive view on the Part A relief. In fact, the court will be aware that in decisions such as Outer, Justice Moseneki indicated that in general, many cases, no view will be expressed on the prospects of the Part B relief. In other cases, as it is indicated in the applicant's own heads, a judicial peek, to use the phraseology of the applicants, will be taken at the prospects of success. In other cases, in order to balance up the competing requirements for interim interdictory relief, a closer look may be taken at the prospects of success. But the clear and crucial factor is that at no stage in the Part A proceedings is a final view ever taken on the Part B review relief. And I'm making these submissions particularly in the context of an interim application pending a review. That gives rise to particular considerations, amongst which is the nature of the prima facie right that has to be demonstrated. It has been said, of course, that the prima facie right that has to be demonstrated is not just the right to review. Again, that was the dictum of Justice Moseneki in outer. In certain circumstances, it may be necessary to have regard to prospects of success in the review if those prospects of success or a successful outcome is relevant to the right which is sought to be protected. So it all depends. In the present matter, the court will have seen that this application was instituted on a Part A, Part B basis, and the Part A papers, the answering affidavit on behalf of the Minister and the Director General, in paragraph 10 at 003-8 of the case line's reference, it's in terms indicated this affidavit deals only with the interim relief sought in Part B. In Part A, as Part B of the review application is to be launched within 15 days of the grant of an order in terms of Part A. And if one were to turn to paragraph 42 of the reply, which is at 004-12 in case lines, one sees there the corresponding recognition by the applicants that, in fact, the papers in due course are going to be supplemented, and depending on the nature of the record, that would determine the extent to which the papers would be supplemented. They say in paragraph 42, the respondents further review that the relief sought in the Part B, sought in Part B of this application will only be precluded by the principle of res judicata or issue estoppel. The applicants are reciting a point made by the respondents that this was an inappropriate procedure, that is to say interim interdictory relief was an inappropriate procedure to adopt in an application which is effectively being heard with applications where the main review challenge will be determined finally by the very same court that is hearing the interim interdict. Now, we'll get back to why we say that that was from the outset an inappropriate procedure in these circumstances. But it's in that context that the applicants say in paragraph 42, and responding to that criticism, they say this is entirely speculative. That is to say, the contention that the issues will be effectively much the same, if not absolutely the same, in the main application. They say this is entirely speculative. It's unclear what impact the court's decision in the HSS review will have, if any, on Part B of this application. The applicants in this matter still enjoy a right under Rule 53 to amend, to add to, or vary the terms of this notice of motion and supplement the supporting affidavit in its review application of the minister's decision. So at all times, all the parties were working within the confines of Part A, and the papers were crafted accordingly to the extent necessary.
Let's just find out where I lost you, or the last point that I heard was when you indicated this application is effectively being heard by the same court hearing the interdict. In other words, this court hearing the interdict heard the main application.
Yes. I'd made the point, and I don't know whether you'd missed that, Judge, that I'd referred to paragraph 10 of the answering affidavit, where the respondents made it clear that the affidavit was being filed in response to the Part A allegations, not Part B. It was confined to Part A. I referred the court then to paragraph 42 of the replying affidavit, where similarly the applicants recognize that the issues in Part B are likely to, or very possibly will be, developed and expanded in the context of the Rule 53 record. And that, of course, goes for both parties in the sense that the position that they have adopted in the Part A proceedings is a position that may and very frequently is evolved and developed in Part B. That was the point that I was making at that stage. And it's in that context that one has the situation that the court that is seized of this application is now seized with an application for final relief in these papers, has heard the two applications directed at setting aside the self-same decisions yesterday and the day before. The court heard those applications on a full set of papers with a complete set of annexures in which all aspects of the disputed decision were fully ventilated. The court will be aware that that decision was characterized by a great deal of inconsistent terminology by all parties concerned at various stages. And as was indicated to you yesterday, that decision was at various stages described by various parties as being a decision not to extend the ZEP permits, a decision to terminate the ZEP permits, a decision to grant a 12-month extension of the ZE permits, and a decision not to exercise powers in terms of Section 31(2)(b to put in place a further exemption regime. Those correspond, or those various conflicting and often confused descriptions of the decision that was made and the power that was being exercised is one of the difficult issues that is going to detain this court. And the court will come to a conclusion based on the nature and consequence of the decision by having regard to the objective facts. The court will pay less regard to what various actors have described the decision as being, and having described what they understood the consequences to be. In certain instances, that may be of evidential value, but ultimately, the court is going to look at the objective facts bearing on the actual decision. And in the context of the power being exercised, will come to a decision or a conclusion in its judgment as to the true nature of the decision, what was and wasn't decided. And I'm making this point because crucial to that decision that the court has to make is, of course, the material that was before the minister on the date he made his decision. That's the starting point of the entire inquiry. And as the court will be aware from the proceedings in the two matters argued before that, that is in fact the memorandum that was prepared by the Director General dated the 20th of September 2021, The court will recall that that was.
Sorry, my
Yeah, Mr. Rosenberg, I just want to find out where you're getting it now, because you're not going to re-argue the matter.
No, I'm leading, if I may just develop this point, it's leading up to what I submit is a crucial deficit in this case, and I'm about to arrive at the point I'm making.
I want to understand the basis upon which you say the applicant is precluded almost to proceed with this cause, that the application that they brought before the court today, and succinctly tabulated for the court.
Yes.
There was no note uploaded by the respondents likewise to forewarn the court of this. So I'm trying to, with the time allocated, we're trying to follow what you are saying.
Yes.
Right. Succinctly give us the pointers so that we can follow where this argument is going to develop to, because I also need to give the other side an opportunity to reply. Let me just find out, Advocate Toby, is there anything else that you wanted to raise?
No, my lady, I think it's really becoming a problem because we are now 28 minutes after 10.
Yeah.
And we either move our application for interim relief or our application for final relief. What is unacceptable is that the merits are being traversed before we've said anything.
Yeah. Okay, but I think Advocate Rosenberg understood now the court's position.
I do understand that. The point that I'm making is that the crucial document and material on which the decision turns is in fact the recommendation of the Director General, and it was in relation to that 4-page recommendation that the decision in question was taken on the 20th of September by the Minister, in terms of which he extended the permits. The point that I'm making is that in the present application, the final relief that is sought is relief directed at setting aside an application or setting aside a decision not to extend the regime. That is the relief that is sought in this particular matter as part of the Part B hearing. The relief that was sought in relation to the applications that you heard yesterday has been framed in the form of the orders sought as a setting aside of a decision to terminate, to grant a limited extension of 12 months and to refuse further extensions. Two decisions described in fundamentally different terms. The point that I'm making is that in the present situation, in the Part A papers, the evidential basis for determining and for this court to properly determine the nature and circumstances of the impugned relief is not present and hasn't been adequately and fully dealt with. That is the point that I'm making in relation to, and by contrasting the evidential material before this court and the evidential material in front of the court in the 2 applications dealt with yesterday. It's simply not possible on the basis of the Part A material before this court to reach a properly informed final conclusion on the nature of the decision, when it was taken, and the details of that decision. It hasn't been ventilated in the affidavit.
The record that you are saying that informed the decision is not before this court. That's what you're referring to. We must make a decision in respect of Part B. That's what you're saying to the court.
Yes.
Okay.
And of course, on that basis, it's submitted that the respondents would be prejudiced by the application to move for final relief in these circumstances on these papers. The proper course in these circumstances, given the decision not to move for interim relief and to move for final relief, would be to afford the respondents an opportunity to supplement their papers if in fact final relief is now sought.
which will result in a postponement of the application.
That would result in a postponement of the application.
And if the application is to be postponed as far as cost is concerned?
That's an issue that can be dealt with in due course.
Thank you, Mr. Rosenberg. Sorry, Judge Malindi, do you have any questions to Mr. Rosenberg?
No, thank you, my sister. I have no questions.
Judge Moto?
No, I have no questions either.
Thank you. Applicant Toby?
Thank you, my lady. Now, the point about prejudice, again, I can summarize that point. It is simply that there is no other document that is coming from the department. The department has told the court rather than us on Tuesday and on Wednesday that the sole recorder of the decision is the memorandum of the DG, which was then affirmed by the minister. In that case, we've got full access to it. In our case, it's the same position they have taken. When you consider prejudice, also you have to look at the prejudice from the side of the applicants. You cannot only look at prejudice which is claimed but not proven by the department. Look at the prejudice on the side of the applicants in the approach that is suggested by the department. Let us postpone the case. That is ultimately what they are trying to drive towards. Let's postpone the case. Now, we postpone the case in what circumstances? In circumstances where we act for 1,000 ZEP holders. The affidavit of the department confirms that on the 1st of July, they will potentially be rendered illegal in South Africa. Will all be rendered illegal. At least the 1,000 we act for, but there is 178,000. So the 1,000 we act for, on the 1st of July, they are illegal in the country. And they've come to court not yesterday. This case has been around since 2021. And now they're not going to get their hearing. The case is going to be postponed. So one has to take a realistic view about where the interests of justice lie in a case like this. And you should be robust and not to entertain delaying tactics, which is really what this is by the state. So if you are to assess prejudice, where there is absence of prejudice because the sole recorder of the decision is one document, and you have to look at the prejudice of postponing the case in circumstances where we've been in court since 2021. And in the next 3 months, we are stateless. And being stateless means you are vulnerable to an arrest or vulnerable to a deportation. And then you are before 3 judges, specially assigned, and you don't get heard. That damages not just us, it damages the confidence of the public to the administration of justice. So you cannot postpone the case, you have to hear the case. You have to be robust in relation to the prejudice they claim because there is none. You have to follow the law because there is no need for the record. We are entitled to ask for final relief where a clear right is established by assessing the answering affidavit of the department. So in summary, that's what we say. And we really ask that we should now get on with the case. It's 45 minutes after we should have started, and we are being delayed by the department. Thank you, my lady.
All right, let me ask you this, Advocate Nkaitobi. The other alternative is you proceed with your papers as it stands.
Yes.
On the Part A.
Yes.
You're not precluded from proceeding only on Part A.
Yes, I'm not precluded. I'm also not precluded, my lady, from arguing Part B. And my learned friend can say whatever he wants to say when his turn comes.
Yes.
What he cannot do is to stop me from talking, which is what he's trying to do.
I don't think he's trying to do that. The question I'm raising as the court, or posing to you as the court, is that you have a Part A that has been enrolled before the court. There's a full set of papers in respect of Part A, and you're entitled to argue your relief sought in Part A.
Yes, but my lady, I accept that. Let me not appear to resist that. But I am saying I am also entitled to urge the court to find for me in final relief. And my learned friend can make whatever objection he has when his turn comes. This is not a preliminary case.
Yes, I understand. All right. Thank you. Any questions, Judge Malinde, that you might have?
Maybe a question of clarity. So, Mr. Ngugai Toby, if you proceed on Part A, it will be on, you say it will be on your papers and the respondents' papers as they are before court now. Mr. Rosenberg says, had they known that Part B would be traversed, they would have supplemented their answers to meet the allegations that seek, or the submissions that seek final relief. What's your response to that?
Switch on your mic. Yeah.
Thank you. Thank you. Sorry, I apologize. So firstly, Justice Malinde, on Majake, a case is brought for interim relief, but the papers establish a clear right. The applicant is entitled to say, I want final relief. My learned friend says he wants to put in another affidavit. He can do that. No one complains about that. He can do that. If he wants to put another affidavit, he can do that. The court will take that into account. And I'm not going to stop him from putting extra evidence before the court if he wants to do that after the hearing. What I am protesting against is that we are not to be heard today on final relief. I will move the application for final relief. The court will decide once I've done that whether or not there is enough material to grant final relief or not, or whether or not there is enough material to only entertain Part A. So none of these are preliminary. These are all arguments that go to the nature of the relief that are sought at the end of the hearing.
And in your papers, you used the phrase that Mr. Rosenberg repeated, that the court may take a judicial peek into Part B. Will the court be justified to do that if Part B is not set down for today?
No, a judicial peek is relevant for Part A. What I am saying is that on Madake, the case, the facts really do establish an entitlement to final relief. And right. Justice Malinde, just remember what is this argument made by Mr. Rosenberg. Just interrogate it for half a second. He says his complaint is that the decision has been described in different ways. Sometimes it has been described as a decision not to extend the ZEP. Sometimes it has been described as a decision to extend further privileges. Sometimes it has been described as something else, 3 or 4 different ways. What does that have to do with whether or not the facts are established that would constitute a basis for final relief? So the characterization of the decision is a matter for legal argument. He can make all of the points he was talking about today in legal argument, that one document describes the decision differently from another document, and he can make whatever submissions he wants to make about the implications of that decision. And one must remember that they are the ones who protested about interim relief. So when we now take up the invitation, they're protesting again.
Thank you very much. Thank you, my sister.
Thank you. That's Mota.
Yes, Counsel Nwatobi, if I understand you very well, you are effectively saying that you want to give them what they're asking for in their answering affidavit. Yes. That if we proceed on an interim basis, that like you had initially wanted to proceed, there would be an issue of res judicata and issue estoppel. Now you're trying to avoid that, if I understand you very well. But you go further than that. You are saying you have met all the Sitlogelo versus Sitlogelo requirements in your estimate. You have a clear right, there's an actual injury, and you do not have a satisfactory relief, yes, alternative relief. Yes. Now, the question that I have is, They are saying with all that, that's well and good for you because you are ready. But with us, we have not been able to ventilate these issues either by way of an affidavit, meaning to attack your clear right, to attack your injury, to attack all that obviously needs to be attacked. And you are saying that's up to them. If they want to file a further affidavit later on, they can do that. You're not going to run their case. Doesn't it put the court in an invidious position where now it will have to decide if they say, we want to file further papers. We understand that you're not proceeding with your Rule 53 as well, in that you're not waiting for the statement, which is for the benefit, correctly pointed out, of the applicant, not basically of the respondent. So you want to proceed. What do we do with their request if they were to request that they want to file further papers? I don't know if you follow me.
No, I do follow. Well, I think I do follow you, Justice Mota. I understand precisely what you're saying. All I'm saying is this request to file supplementary papers happens all the time. Whether it was an interim relief application, a party comes and says, look, the point has come, I want to file supplementary papers. That has never been used as a basis to block a party from running their case. If ultimately you decide that it's in the interest of justice to grant them leave to file, do that. I cannot stop them from doing that. What I'm simply saying is that this morning I should be allowed to argue my case, move for my right, my clear right, final relief. My learned friend will come and object to it and say it's inappropriate, it's prejudicial, etc. There is no reason to have an hour spent on a so-called preliminary objection on a matter that really goes to the merits of the case. If you are ultimately satisfied that I've met the requirements for final relief, there is no prejudice to the respondents, you may grant final relief without giving them a chance to put a supplementary, or you may give them a chance to put a supplementary. That is all your discretion. If ultimately you come to the conclusion that the best approach to take is that you should only entertain interim relief, notwithstanding the objections that have been raised by the applicants, so be it. But what we are fundamentally opposed to is a stratagem.
Justice Collins, may I reply at this stage very briefly?
Just hang on, I need to find out whether that's the only question that Judge Mota wanted to ask.
Yeah, no, so far that's I'm okay. You can move on.
Thank you. Your reply, Mr. Rosenberg?
Thank you, Justice Collins. May I emphasize very firmly that this is not a stratagem, that in the first instance, in as much as counsel insists that the exigencies and urgency of the matter is such that it's imperative that the application for final relief goes ahead today for the reasons he's indicated, you'll be aware that there are 3 applications for final relief on this very issue, 2 of which have been argued by you, in respect of which the rights of all 178,000 ZEP holders are being presented to you. So whether or not the final relief in this matter gets heard today must be seen in that context. Secondly, it's not a question now of the applicant yielding to what the respondents had always wanted. The respondents at the outset adopted the approach that seeking interim interdictory relief was an inappropriate procedure to adopt in these circumstances, given the timelines of the various applications. The various applications, in particular the HSP application and the COMSA application, were launched in the middle of 2022, June 2022 HSF, COMSA 20 July 2022, where it sought to intervene. ZIF was launched, or the present application launched at essentially the same time. But rather than adopting an approach of seeking to intervene and effectively consolidating, where essentially the same challenges were made to a decision which happens to be described in contradictory ways, but it's clearly the same decision, at that stage, it was appropriate that the applicant in this matter should not have persisted with an application for interim relief, particularly when it persisted with that application over a period beyond 5 October last year, throughout the 5 or over 6 month postponement of the hearing up to today. And it is only effectively 1 court or 2 court days before this matter was due to commence that the applicant seemingly appreciated the impact of the point that had been made all along, that it made no sense and would give rise to any number of procedural paradoxes and difficulties for it to be arguing for interim relief and demonstrating prima facie prospects of success in a review, where this very court was finally determining the review, and that they would then go on to a Part B in due course, well, when this court had already determined the review in Part B. The procedural inappropriateness of that was obvious, and it wasn't recognized when it should have been. What ought to have happened is that the applicant in this matter, whether before or shortly after April last year, should have done what it did the day before these proceedings commenced. It should have recognized that asking for interim relief in this context was inappropriate. It should either have intervened, or it should have made it clear that when his application was continued to be effectively consolidated with these applications for simultaneous hearing by the same bench, it should have done what it seeks to do now belatedly at the last moment, to in fact move for final relief, and the adjustments to the affidavit could have been made well in advance. And we would then have got rid of the inconsistencies that in fact you face today. You're now faced with an application for final relief in terms of which a decision is described in terms entirely different from the decision which is the subject of the draft orders that were presented to you yesterday. We know it's the same decision, the September 2021 decision, but all of those problems are created entirely by the applicant's choice of an inappropriate procedure and the applicant's failure to do something about it timely. It is not, and I must emphasize this, it's not the minister just seeking to delay. This matter is not being delayed. You've heard the matter yesterday, and you are enjoined to come to a decision as with all speedy deliberation. Postponing this matter is not going to postpone any evil day for the minister whatsoever.
Yeah, but this is what I want to get to. So as far as I understood your argument, you're not seeking a postponement per se. You're saying if they wish to proceed with the Part B portion of their relief, then you would want to have an opportunity to supplement your papers if needed, and that will necessitate a postponement. But you are ready to proceed to argue the Part A.
We are ready to proceed to argue Part B, but we make the following submissions and then I will close. We will argue, as we've argued in the heads of argument up to now, that moving for interim relief in these circumstances is inappropriate. There was and remains an alternative remedy. And secondly, we've presented with submissions and a draft order in terms of which we are told that the applicants are not pursuing interim relief, they are pursuing final relief.
Yeah, but the point I'm making, Advocate Rosenberg, is you are ready to argue even that argument. You are ready to argue it.
To argue which relief? The interim relief?
If the court has to make a decision now, not so. You confront it with a request, we have to rule on it.
Yes.
If the court rules that the applicant is to proceed only in respect of Part A. The respondents are ready to argue that point.
The respondents are ready to argue the Part A relief if the Part A relief is to be entertained and reinstated, as it were.
Well, it's still before the court. The notice of
Yes.
motion has not been amended, sir.
Yes.
Sorry?
Mr. Rosenberg,
Oh,
as,
just-
as my sister has indicated, if you can hear me,
Yes.
what you've just traversed now will be your answer to Mr. Ngugaitobi while moving Part A, and he urges the court that nevertheless final relief has been established in the papers as they are in relation to Part A, and then you may then make those submissions. Is that not so?
Yes, if the court says that the argument can properly proceed for final relief, and we are going to argue for final relief, I would then have to repeat my submissions as to why, in the circumstances, it's not appropriate on these papers and the nature of the prejudice.
Yes. Thank you.
Thank you, Mr. Rosenberg. Any questions on the side of Judge Mota?
No? No questions?
Right, can we take an adjournment at this stage then? So that we can have regard to what has been placed before the court, and then we'll reconvene after tea. Thank you.
My lady, I confirm resumption of proceedings for case number 006-386 of 2022. May please the court.
Thank you. Are all the parties online?
So, Advocate Rosenberg,
Yes, I'm online. Thank you, my lady.
and there's the applicant's counsel as well, my lady.
Okay, and Judge Malindi, I don't see him. Is he online?
Judge Malindi is online, my lady.
Okay, thank you. Thank you. The ruling of the court then. The present application consists of a Part A and a Part B. Part A as to the notice of motion, wherein the applicant seeks an interim interdict pending the determination of Part B on a future date. This court was presented with a full set of papers in respect of Part A, and thus accordingly prepared for the hearing in respect of Part A. The parties prior to the enrollment of the application for this week met with the Deputy Judge President of this division for the allocation of these specific hearing dates. And at all times, it was the position of the applicants that only Part A of the application is ripe for hearing. This is the basis upon which these dates were allocated and subsequently the enrollment prepared. In addition to this, the parties were directed by the Deputy Judge President to prepare a joint practice note for the court, wherein they were called upon to identify the issues that this court was called upon to determine. Therein, the parties clearly stipulate that this court was called upon to determine Part A, that is the interim relief of the notice of motion, during these dates are allocated. Now, on the 6th of April 2023, this is with no business day to the date of the hearing of the first day of the hearing of this application, the applicants then filed a supplementary note. In this, a supplementary note to the heads of argument. In this note, they now contend that this court would be entitled to grant them final relief. Coupled to this, they also on the 12th of April 2023 uploaded a proposed draft court order for the court, wherein not only a final interdict is now being sought, but also a final determination in respect of Part B. This, the respondents contend, is prejudicial to them. The evidence presented by the respondent does not support this relief now sought in respect of the proposed draft court order by the applicants, nor has the respondents been given an opportunity to supplement their papers timeously where necessary, and it prior to the hearing date of today. And it would therefore be impractical also for the respondents to do so now. The prejudice as such to the respondent is manifest. Consequently, they request a postponement of the application if this court is inclined to consider granting final relief now contended for by the applicants. In our view, the applicants are not precluded to proceed with Part A of the application, nor is the respondent precluded to present its case in respect of Part A, as this is, in our view, what is before us today. This court is mindful of the urgency of this application to be determined, and as such does not deem it prudent for any part of this application to be postponed as contended for by the respondents. It is for this reason that this court finds that Part A is to proceed today, as this is the portion of the notice of motion that have been enrolled for adjudication by this court.
Thank you, my lady.
Support, please.